Good afternoon, everyone. My name is Attorney Devin Shanley with Peterson, Berk & Cross, and this is another edition of Lunch with a Lawyer. This week, we're going to talk about what happens if I die without a will. This is a question I get a lot. It's a personal favorite question of mine because it presents a lot of interesting situations, and it gives me a chance to use some of the big fancy words that I paid way too much money to learn in law school. Specifically one called intestacy. Just to review our format, as always, I'll talk about what my lunch is. Please talk about what your lunch is. I would love to hear it. I'm going to guess this week your lunch is better than mine, and that's okay. And then we will open up. I'll talk about what happens if you die without a will. Do that. I'm hoping for about 10 to 15 minutes, and along the way, I'll answer any questions that you may have, and then also reserve time at the end for your questions as well. Some housekeeping items. As you ask questions, what I'll ask is, as always, please ask on general things, not anything fact specific. If you think that you have a situation where you need to ask about your case and say, well, my brother just died without a will, and I think I'm going to do this. How do I get this going? How does this go about? Then what you need to do is you need to call and schedule a consult with one of the attorneys at Peterson, Berk & Cross. That will probably be me. Hi, I'm Devin. And we will happily sit down with you, give you a free consultation, and talk through what that issue is and how we can help give you a solution. Our contact number is right on our Facebook page, on our website, and I'll even give it to you now. It's 920-831-0300. So feel free to call. All of the attorneys here are very friendly. We will happily sit down and talk with you, walk through that, and talk about what sort of solutions that we can offer and the courts could offer as well. So with that, today's lunch for me is going to be my coffee. It's a dark roast. It's great, and it's got a slightly sarcastic mug that my paralegal gave to me a couple years ago that I absolutely love and love to drink around the office. So if you see me drinking coffee sometime, it's probably with that mug. So thank you, Katie, for the mug. Thank you all for joining me. What lunch do you have? So please share that, and let's get started. It's not unusual that I have somebody in an estate planning context say, well, Devin, what happens if I die without a will? I mean, that's all just going to end up in probate and get eaten up, right? And the answer to that is going to be, yeah, probably it's going to be in probate. It might be eaten up, it might not. One of the early questions I had here in Lunch with a Lawyer is, what is probate? I might go back to that at some point. In fact, I think what is probate was my very first. We'll try and put a link to that. It's on the Facebook page as well, or on the firm's YouTube channel, which, by the way, if you're really enjoying these, enjoying some of the other content from myself, from Attorney Schlemmer, and all the other attorneys here at Peterson, Berk & Cross, check out our YouTube page, where we have all that archived as well. You've got some of the stuff from my page with some story time, happily ever afters. You've got some of the presentations Attorney Schlemmer has done, and a lot of great content that you should go ahead and check out, including what is probate, to answer what is probate and why it might not eat up everything that you have. But go back to our topic. With today's going to be, what happens if I die without a will? Well, when someone dies without a will, they use a big fancy term called intestate, or it's going to follow the laws of intestacy. Now, this isn't some specialized disease. It's just a fancy way of saying this person died without a will. The laws that we have here are going to be default laws. What that means is, if you don't do anything, the state of Wisconsin will just give you these rules that your heirs will just have to live by on who gets what and how this is going to be handled. If you don't like those rules, then you need to create a will, or form a trust, or create a beneficiary designation, or so on and so forth. But if you do nothing, this is what you're going to get, and you're going to like it. Or you won't care because you've passed on, but your heirs are going to have to, and they're going to like it because that's just kind of the way of it. What do the laws of intestacy say? Well, in Wisconsin, there's going to be a couple different things. One of the first questions we're going to have is going to be, was the person who died married? If the answer is yes, then the second question is, was all of the children from this marriage the product of the marriage? Or were there children from outside the marriage that would be in the mix, that would be potential heirs to this person? If the person is survived by a spouse, and that spouse is the parent of all of the children, so there are no children from outside the marriage, then the surviving spouse gets everything. Easy peasy, things move on. If there is a child from outside the marriage, even if it's just one child, then things start to get complicated. Then we're going to start dealing with the issue of marital property. Spoiler alert, next week is going to be, for what our topic of Lunch for a Lawyer is going to be, what is marital property? So tune in next week to get a more detailed example of what this is. For anybody who's had the pleasure of going through a divorce, you probably have a decent idea of what marital property is or what the issues of marital property would be. This would also come up in death. When you have a situation where you have a surviving spouse and you have children from outside the marriage, and specifically when you have the person die intestate. This is a lot more common than you might think, in which case the spouse at this point gets a divorce that they really didn't expect. You're going to have to divide out what the marital property is, and the spouse will get 50% of the non-marital property that the person has and their marital property interest. What this effectively comes out to be is the spouse gets half, and the children from outside the marriage divide the other half. This can be complicated. And it will start to bring up a lot of different issues of what is the value, what is going to be the marital property interest, and a lot of issues that kind of surround this. It's why when I sit down with clients and I deal with an estate plan, one of the issues I talk about is I say, do you want a marital property agreement? People say, what? I say, well, a marital property agreement is kind of like a prenup, except it's after you're married. And then they look at me and they say, but I'm not getting a divorce, Devin. Why do I need that? And then I try to explain, well, it can also be an estate planning tool, and you don't know who's going to come out of the woodwork and say, no, that's marital property, no, that's not, and start to cause issues. And then at this point, I'd say 50 to 70% of my clients all kind of roll their eyes and say, but Devin, come on, that's not that big of a deal. And the reason why I bring it up is for that 20%, 30% where it is going to be a big deal, where even I have run cases on it where it can become a very big deal, and the person who actually caused the problem is the one who's dead, and they don't care, but everybody else is sorting out a big, giant mess. So as you're thinking about getting your affairs in order, marital property agreements are that, or a will. A will will override these issues, like I said, and if the will just says, give everything I have to my spouse, the laws of intestacy are not going to override that. Everything goes to the spouse. Now that's your stuff. A will handles more than just your property and who gets what. It's also going to name the people who are in charge. It's going to name who gets your children if you have minor children. There'll be a lot of different issues. So what order creditors get paid in? Does anybody get something without a lien attached to it? So on and so forth. What happens with all of that with intestacy? Good question. Who is going to be nominated as personal representative? I say in a tongue-in-cheek fashion when I'm talking with clients, it's going to be whoever runs to the courthouse first. It's not literally like that, but it effectively could be. When you have someone who's died without a will, even if you've had somebody who's died with a will, you're going to need to start a probate action in that situation, which means you're going to need to put in something called an application for informal probate or formal probate or special administration, depending upon which one of these is going to be used. At that point, you're going to nominate who's going to be the person in charge, who is going to be the personal representative. The will is typically going to direct that. Now, if someone doesn't like what the will says, they certainly can nominate somebody other than what the will states, but the court is going to look at that, and unless they have a whole bunch of people saying, you know, everybody's okay with it, and so even though the will says this, I'll override it. Unless you have all of the people involved kind of signing off, it's going to be difficult. You're going to need to prove why the will shouldn't be followed. If the will doesn't have anybody, then it's going to be the person who is filing the paperwork is probably going to nominate themselves, or at the very least, they're going to have a lot of say over who is going to be the person nominated. At that point, the person filling out the paperwork or the attorney that they hired is probably going to contact all the potential heirs or interested parties and send some sort of thing saying, well, Uncle Jack is trying to become personal representative. They're going to do all the paperwork. Please sign this, and it'll be something called a waiver and consent. At that point, those people can sign off on it, or they might contest, in which case we'll have a hearing. Either way, when we're talking about cost associated with this situation, we will see whoever is setting that tone is going to have a lot of say. Probably not final say, but it might sometimes just boil down to who is the first to file, which may or may not be what you wish. That may or may not matter. It's going to depend a lot upon your fact scenario. And that's going to be who's going to be in charge. The next is going to be who gets the kids. A will direct this as well. This will be a process called nominating a guardian of the person. The law in the state of Wisconsin on this, as of right now, and I should probably note, today is June 11th, 2020. Why do I mention that? I've never mentioned that in any of the other Lunch with Lawyers. Good question. The reason why is when we talk about guardianships in this fashion, the law in the state of Wisconsin is changing. In fact, in a future Law of the Lawyer, I'll probably start talking about, well, who do you call if there is an emergency with children? By the way, in the comments section, even if you're watching this not live, put a note if you're interested in that one, and I'll move that up the calendar. Right now I'm planning for that in August, because in September, our law in the state of Wisconsin is going to shift dramatically. In the past, what that's been is all of this has been handled through the probate court. The main reason I surmise for that is because the main assumption was this was going to be in these sorts of situations. Both parents die, and we need to name a guardian in that place. Over time, more and more, we started to take on what people would refer to as private guardianships, where you'd have parents who are struggling with addiction issues or some other issue. Maybe they're in prison or they can't parent for this, that, or this other reason. And it doesn't quite get bad enough that CPS is removing the children, but it's bad enough that their concerned relatives, they would use that same statute in order to gain a guardianship over that. And the statutes really didn't have that built in as to what that meant or what happened in that situation. And so the legislature has changed that law. But in the past, it's always been handled through the probate court. Now it'll be handled through the juvenile court. Why does that matter? Well, it'll matter for people like me. In the case of this conversation, what if you die without a will? It's all going to be the same. You don't get to name that person. You don't get control over who is going to raise your children, who is going to instill values after you pass. You don't get any say. Will your family figure it out? I really hope so. But if you don't get a say, you don't get a vote. If you're okay not voting for that, then by all means, don't get a will. If you do want to say who would have that, even if you're going to think to yourself, well, I don't know who I would name. There's a difference between not knowing and being uncertain and thinking that you just don't want a choice and just saying, well, I'll let whoever is alive figure that out. But that would, if you die without a will, then that is literally what happened. You don't guide the court. You don't get any say. and we don't know what that's going to be. We can't make a prediction. That might again be whoever gets to the courthouse first, or who looks the most sympathetic to the judge that day, who bothers to show up, are going to be some of the questions that we have, or who even gets notice. If you're thinking someone that might not naturally get notice or might be far away, they might not find out about the proceedings in time to really intervene and try and change things. So keep that in mind, and remember, a lot of when we have this intestacy, it just takes away your say over it. You just get what you get. There's one last big concept that we have inside of the laws of intestacy that I would like to touch upon, and that is, and when we talk about who dies without a will, and that is something called heirs. And this is where I'm going to take a stop, and I'm going to talk a little bit more freely about a TV show that I deeply love, and I'm not afraid to say it, even though I might get a little bit of flack because you don't think Macho Lawyer typically likes this show, and that is Downton Abbey. Why do I love Downton Abbey so much, and why does this matter when we talk about heirs? The reason why I love Downton Abbey is because it's good old-fashioned estate planning drama. I mean, you get lawyer shows all the time that talk about criminal law or civil law, maybe even family law. And you have these dramatic courtroom scenes where the lawyer is fighting for justice for the victims or fighting for the wrongly accused defendant. And it's great drama, and there's impassioned speeches and judges making rulings and all sorts of stuff. You don't find too often, deep-seated estate planning drama where people are starting to think about who's getting what and who's getting all of the riches and all that sort of stuff. It's hard to translate into an American circumstance because, how often do you want to hear about trust funds and things like that? I can think of, let's see, Batman, no, not Batman Begins. It was Batman Begins. In Batman Begins, there's a small estate planning drama, but that's like a C or D level plot where it's mostly you see Bruce making a few phone calls and getting control of his company back through trusts and all that. And that's more corporate law even than estate planning. And come on, if we're going to watch Christian Bale suit up as Batman, we don't want to see Bruce Wayne on the phone call talking about what trust fund is paying for the stock to buy out the bad person. We want to see him punching the teeth of criminals. That's what we came for. So estate planning drama tends not to be it, but in Downton Abbey, you get it, and it's awesome. Why is Downton Abbey estate planning drama? It's talking about willing out this massive estate that funds everything, and it was caught in this archaic system of willing property over time called a fee tail, which I had to slug through in law school, and I wondered, this has been abolished. Why do I have to learn about the fee tail? And then I watched the first season of Downton Abbey, and I thought, this is the fee tail. This is amazing. I love this. And I watched until season 3 when Matthew died, and I thought to myself, why are you killing Matthew? This is just horrible to me. And then I stopped watching out of anger. But there it is. And so if you watch it, it's stuffy British people talking about estate planning terms and estate planning drama, and you should see that in your life. Why does this relate to heirs? Because it teaches us an extremely important question about what is an heir, and something that we often don't think about. Heirs are living people. They are not dead people, typically. There's a couple exceptions. Generally speaking, they are not living people, or they are living people, not dead people. Why is that important? Well, in the first season of the first episode of Downton Abbey, everybody is caught up because the heir died on the Titanic. This throws everybody into a tizzy, and they don't know what's going to happen. Why? Because, short story, with the fee tail, the main head of the family, Lord Grantham, can't will the property to whoever he wishes. The land is literally caught up in something that an ancestor of his centuries ago put in called a fee tail, meaning it goes back to the heirs of that other guy's property way back when. So his heir, his living relative that's continued on, gets it, nobody else. And they have no control over that. So the house, the employment, everything about life in this countryside is going to be completely upended for when this guy dies. They don't know who the plan is. They don't know who's going to be in charge because of somebody who's been dead for decades, if not a century, is determined a long time ago. And this is kind of shaking them to their core. And that's very understandable if you think about it, because heirs are living people. So the question of who is the heir becomes kind of a really important thing, and it ends up being this nerdy middle-class lawyer from London, and love happens and whatever. But was that guy the heir? No, because as I said, he died in season 3, and Lord Grantham's still alive. Living people are heirs, not dead people. You have to survive the person who has died. So if we say in your will, or if we're dealing with the laws of intestacy and we're going to look for this decedent or the dead person's heirs, then we're going to be looking for the closest living relative at the time that you're alive. How do we determine that in this crazy world? Well, we're going to use something called the table of consanguinity, which I absolutely love saying. Consanguinity, well, when you look at the word, sanguine can mean good or blood. And con is kind of like chili con queso. Con, if you've studied Spanish or any Latin root language, or most Latin root languages, con means with. So it's a table with blood. Who has got the closest blood relation? Now, because we're a progressive, fair-minded people, we'll also throw in legal attachments as well. So if you're legally adopted by the person, then you're considered having that same kind of blood, or you're within the same realm. At that point, we're going to look for the closest living relation. If you look at a family tree, in short, you can Google this. It's called the table of consanguinity. Basically, what you'll do is you will go, you'll first look down, lineal descendants, your children, your grandchildren, your great-grandchildren, your great-great-great-great-great-grandchildren, etc. Then, if there's nobody down that line, then you will look up. You will go to your parents. Most people have parents. People as a whole are not, born out of a tube. If both parents have died, then you will go to lineal descendants of your parents, your brothers and sisters, your nieces and nephews, your grand nieces and nephews, so on and so forth. If you don't find any lineal parents or lineal descendants thereof, you will go up one more time to your grandparents. Because again, your parents were probably not born in a tube either. And then go to lineal descendants of your grandparents, aunts and uncles, cousins. If we run out of people, then the state of Wisconsin kind of gives up, and we'll take the money and put it into the education fund. It's called "it's cheating." Some people think of it as "it's cheating." And that's the long and short of who would get the property. How do you plan around that? Well, you use a will, use a trust. Another important note, let's say you don't have a will, but you do have most of your money sitting in a 401k, and when you're sitting down with your financial advisor, you go, they look at you and say, who would you like to get this money after you die? And you go, I don't know, my Uncle Fred. If you die, Uncle Fred gets the money. So that would be what's called a non-probate transfer. Again, intestacy only applies to probate if it's not directed by a will. So if you have these non-probate transfers in place, then we'll do this. Intestacy as a whole fits very well and tends to mesh with people when they have a family that looks like the Cleavers. If it's mom and dad, and then all of their kids are by through that marriage, and there's no blended family, and there's no stepsons, or if there's no half children or half siblings, or this is my third marriage and I've got different kids along the way, so on and so forth, it works fine. It'll add some paperwork, but it might be exactly what you want, in which case I often get the question, well, then why do I need a will at all? The answer is A, you don't know what your laws look like, and B, you still will probably want to say for who's in charge. Who's going to be the one that actually sells the house? Who's going to be the one that actually raises your kids? Then you might want to be able to say that. And if you just don't care, then you might not need a will at all. I've actually had 1 or 2 times where I've stated that to people, and they welcomely took that risk. It's going to be dependent upon your circumstance. All of this means, if this has brought up questions for you, that you should talk to an attorney. And if you do need to, as I stated, you can call one of the attorneys here at Peterson, Berk & Cross. We do give a free half-hour consultation, and we'll be happy to help you form a legal solution, because at Peterson, Berk & Cross, we're specializing and you.